I hope people are coming back.
Yeah,
Yeah, this is
it's okay.
just trying to make it good for everybody. All right. Yeah, people are coming back. This is completely my sorry, everybody.
It's okay. It's okay. We are all learning.
Yeah, the thing just went off. That wasn't the plan. Mm. All right. I hope you are seeing my screen now. Kevin? Mr. Kevin?
Yeah?
Are you seeing the screen?
No, I've not seen the screen.
Not yet.
Not yet.
Oh.
Okay, it's coming up now.
Right, you're seeing the screen. All right. So
Yeah.
I think we are good now.
Yeah.
Sorry, everybody.
It's okay.
Yeah. All right. We'll go live any moment when the people get in. About how many people are here now?
Yes.
Union is
Yes.
back. All right, Joy is back. Please, can everybody come back? I'm sorry, I didn't know that everyone was logged off. I think we were on 10 before. I don't
Yeah,
know that.
we were 10 this morning.
Yeah. It's a very big mistake.
It's okay.
Let me test everybody to come back. All right, Say is back. Joy is back. That's good. What are we waiting for now? Right. How many remain? All right. iPhone is Nancy is not yet back. All right. Omora is back.
7 people are back.
Yeah. So remaining 3 people.
Yeah.
Oh my God. Sorry, everybody.
It's okay.
Chinanyanam is not yet back. And Nancy is not yet back. Hi. Let me see what I can get Nancy here. All right, I think we should go ahead and wait for them to come in. I think that's what we do.
Yeah.
We're going to get ahead to wait them to come in because we can't continue. So indirectly we are. All right, one person is in. I think who is in? Amona is in. All right, Chinanyanam is in. All right, so remaining 2 persons more. So we are going live. Why I wanted to go live is that you can take
another person has joined.
All right. So
Okay.
why I want to go live is that you can, at my own time, go through what we just discussed. I think that will help. Sorry for the disruption. So we are going live right now. All right. Everybody's back. Good. Yeah, everybody's back. All right. So good morning, everybody. Once again,
Good morning.
we are live right away. So that will help everybody here to be able to go back to through what we discussed and get what he or she missed. So today we continue with our chapter 3. We have had I hope people are coming back. I think a lot of people that good. Please, I'm very sorry for the disruption. I'm trying to make it easy for everybody, so that
just trying to make it
so even if you
good for everybody.
The person is not, you can just go to the YouTube and get.
Yeah, people are coming back. This is completely my sorry, everybody. It's okay. It's okay.
Right. So
we are all learning. Yeah, the thing just went off. That wasn't the plan.
All right, that's good. Nkem says share the link. Yeah, I'm gonna share the link after the recording. The the YouTube link will be shared to the platform after the recording, after the class. Is that okay?
Okay, that's nice.
So we can share it when we finish. All right. All right. So let's go to chapter 3, where we stopped yesterday. We had.
I hope you are seeing my screen now.
Everyone should be seeing.
Yeah, we are seeing it.
All right.
Mr. Kevin? Yeah, I'm seeing it. Are you seeing the screen? Yeah. No, I'm not seeing the screen. Not yet? I'm seeing the screen. Not yet.
All right, good. So it started from where we stopped. So let's go ahead. We are
okay. It's coming up now. Well, you're seeing the screen. All right. So I think we are good now. Yeah. Sorry, everybody.
It's okay. Going to hold on. I'm gonna stop it. So all right. So let's go ahead. The exam tip, we talk about the CLOG.
Right. We go live any moment when the people get in. About how many people are here now? Union is back. All right, Joy is back. Please, can everybody come back? I'm sorry, I didn't know that everyone was.
All right. So let's go.
That's very big. Right. How many remain? So we are going live right now. All right, everybody's back. Good. Yeah, everybody's back. All right. So good morning, everybody. Once again, good morning. We are trying to
all right, good. Let's go ahead. So in the last night we almost finished chapter 3. What did we do? We talked about offer and acceptance, and we were able to explain what offer and who makes the offer, who accepts. And we talked about contract of adhesion, which we said is contract done by one person, prepared by one person. That person who prepares is the insurance company, where he said either you take it or you leave it. It's not really forcing you, mandating you to take it, but he leave it there for you, either for you to take or to leave. So at contract of adhesion, contract prepared by only one party. In a contract, contract is about 2 people or 3 or 4 people, but insurance contract is contract with 2 people. And one person prepared the contract. So it's called contract of adhesion. Now, insurance contract is a unilateral contract because one party that makes that contract enforces the contract. Then conditional too is conditional because remember, in the consideration clause, the promise to pay benefits is conditional upon the loss. So insurance contracts are conditional. The only thing that insurance contract is not a personal contract. A personal contract can be related to your home insurance, your car insurance, because when you put insurance on your home or your car, you are putting insurance on yourself. You are not putting on that car, because when you sell that car, the next person that buys is going to get insurance on the car. So the same thing with home. So, but insurance contract is contract of value because the benefit is already agreed upon. But every other contract, like car or home insurance, is contract of indemnity. So that's what all of us should know too. And we went ahead to talk about value contract, which I just said now. Our insurance contract is value contract because what? The benefit is already predetermined. What remains is that when the loss occurs, then the benefit will be disbursed. But indemnity contract or contract of is a contract just like contract in properties and contract in car. Those are indemnity contract because the particular loss what you lost is what will pay you back. And that's why we say in indemnity simply means they attempt to bring you back to your original, the position you were, the financial position you were before the loss occurs. So that is indemnity contract. So indemnification simply means reimbursement. So in case if you see it in the exam, don't freak out. Indemnification means simply reimbursement. So indemnity contract is a contract of reimbursement. Contract that if anything happens, if you experience loss, the loss will be what you lost will somehow be paid you back. And they're not expected to make any profit out of it. They will pay you exactly what you lost. So that is contract of indemnity. It's not the same thing with life insurance. Life insurance is contract of value, is a value contract, because what happened when a person dies, that particular disbursement or that particular benefit that will be paid is already known. It's known during the contract. When the contract was signed, that's when you know it. But in indemnity contract, it's not like that. What you be paid depends on what you lost. Of course, if they send the assessment team to come and check what you lost, they're going to examine it, find out what you lost. They're going to actually reimburse you what you lost. So those kind of contracts is called indemnity contract. Life insurance is not an indemnity contract. And life insurance is not a personal contract. So that's what everybody should know. Don't get confused with it. We went ahead to talk about insurable interest. We said for you to have insurable interest, you must what? Be able to have a financial loss connected to that person that the loss occurred upon. If you do not have any personal relationship with somebody, thereby if that person experiences loss, you will be somehow financially troubled. If you cannot not incur any financial loss when that person have such a problem, then you don't have insurable interest on that person. So therefore, what we now mean by insurable interest is this. The kind of people you have insurable interest is people around you, your family members, you have insurable interest in them. Those who are living in your house, you have insurable interest in them. But outside that, you do not have insurable interest to outsiders. So what that means is that anybody do not have any legitimate financial loss. If anything happened to that person, you do not have insurable interest on that person. Means you cannot put a policy on the person. So we went ahead to talk about what again do we say? We talk about negotiating and issue insurance and policy. Of course, utmost good faith. Whatever information you are bringing to the insurance business must be what? Factual. You must not lie. You must say the truth. You must say what it is. Don't conceal, disguise, or deceive the agent in order for you to get the policy approved. No. You must say it as it is. The insurance issued the policy on the fact that the applicant was truthful. So the insurance company going to give you the policy based on the truthfulness you have. So whatever you say, they assume is true. So you have to be very, very factual. Do not lie. Do not say what is not there. Warranty, your statement, which is the application, is not a warranty. It's a representation. So whatever you put on the application is a representation. It's not a warranty. If it's a warranty, it means that you are guaranteeing that everything there is true. But the fact remains this. Whenever you are filling a form, in as much as you are filling what you're feeling is factual. But however, there's likelihood that in some places you can make a mistake. So let's assume you're writing your name. Fortunately, where you put A, you put D. Is a mistake. Is a common mistake that can happen. So in that case, if you say it is a warranty, which means you guarantee that it's true, then you have lied. You have committed fraud. But it's a representation which you are making to the best of your belief or best of your knowledge. So you now regard this as a representation, not as a warranty. So representation are not part of a contract and need to be true only to the extent that they are material and related to the risk. Statement made by applicants for insurance are representation and not warranties. So any statement you make during filling of a form is a representation. They can never be a warranty. If you said it's a warranty, and if there's anything found there missing or anything did not stay as it is, a likelihood of making a good mistake is always there. So if you make such mistake and you said it's a warranty, then you are putting yourself into a big problem. So that is why a statement made by applicant when you are filling the form, the insurance application, is regarded as a representation and not a warranty, please. So that's what we said it last night. We went ahead and talked about concealment. Of course, you are required not to conceal anything. Do not conceal anything. A recession, recession means that the contract is made null and void, which means that contract does not have the 4 elements of a contract. So we are required not to make any concealment. What is again? We talk about void contract and voidable contract. Yes, this is where people make common mistake. When you say it's a void contract, that contract does not have all the elements of a contract in there. So that contract, it does not exist. It's never a contract to start with. So let your mind not go to the fact that when you see void contract, it thought it's contract that is cancelled. No, in void contract, that contract is just like empty. It's not yet a contract because it lacks all the elements of a contract, which are 4 of them. So we now come to voidable contract. Voidable contract is already a contract in existence. That contract already have all the 4 elements of contract is in there. So that contract is a contract in existence. So you can avoid it. You can avoid it means that you can terminate it. Insurance contract is voidable contract. You can void it. You can decide not to say, oh, I'm not going to pay my premium. I'm tired. I'm not going to do this. I'm not going to do that. The insurance company can equally terminate you based on fraudulent information representation you put on the application. So that's a voidable contract. But void contract has not yet existing. It's not yet in place. It doesn't have all the elements of a contract. It lacks at least one of the elements. And when a contract lacks at least one of the elements, that contract is not yet a contract. So please don't get confused when you see void. You thought it's contract that is cancelled. No. The contract that is cancelled is voidable contract. This one is a contract in existence. So if it's a contract in existence, which means this contract is already binding, and some of one of the
But they decide to set it aside.
Yes, one of the team can decide to say, I no longer want it. That is voidable contract. Voidable contract. So get into the understanding of how to distinguish between void and voidable contract, please. Void does not exist. It lacks one of the elements of a contract. Voidable means that the contract is in existence, but which means that contract can be cancelled. Either one of the party can cancel it. That is voidable contract. Now, we talked about we talk about cancellation and fraud. We said anything that's outside, and when you said their representation are warranties, are guaranteed. So what it means that if anything found there, it means that you're committing a fraud. And in insurance business, fraud is a very important issue that insurance company and government does not look aside of. They pay close attention to it. So any false statement somebody made is a fraud. So Do not do that in contract. Waiver is only happened in when that somebody deliberately, especially the insurer deliberately, cancel, surrender the policy. A waiver is also a deliberate, voluntary, intentional abandonment of one's own right by the insurer. You ask yourself, what can make an insurer to abandon their own rights? Of course, when they get themselves off of the contract, they already removed themselves from the contract. So that is waiver. I don't think it's much important. So let's
What
go.
do you say is the meaning of that estoppel?
Estoppel. Estoppel is remember the definition is struggling. Estoppel is that when is that thing that can prevent the insurance company
The insured.
from
Okay.
prevent the insurance company from I think using your own rights. They prevent the insurance company from using
When
your
they
own
give you
rights
false
against you.
information.
Yeah,
Okay.
yes, I think that's what it is.
I
It
got it.
prevent the
Yeah,
insurance
yeah.
company. It's the definition is something you can't define. It's somehow.
I've remembered it now. I've remembered it.
That's why I said everybody should write it down. I remember in my own exam, it was difficult for me. I was dancing around. I couldn't know what it means. And if you don't know what it means that you can't explain it. That is not the truth. I think we should have to look. We passed it already, I think.
Yeah, we passed it, but I've remembered the meaning now.
Pass it. I told everyone to write it down. I know it's a way of you not of insurance for you to get your right when insurance company not to use your right, something like that. That is what it means. The insurance company will not use your right on something that
It's the kind of a protection.
protection to
When
the
insurance
insured.
company gives you wrong information.
Yes, it's
That's
protection.
what protects you. Yes.
Estoppel. I think that is estoppel. Let me see. Yeah, I think that's exactly what it means.
Yeah, that's what it is.
Yeah. Yeah, like what happened? Like when the insurance company said something, and if it prevents them from going back, stop someone from going back to their own word or deny something they previously said or did. For instance, you go to as an agents come to tell you, maybe tell you that, look, if you put this policy, tomorrow you get 10,000. Agents said it. And remember, agents work for insurance companies. So whatever agent said is assumed that that's what the insurance company said. So the agent told you that, look, if you write this policy today, in the next 1 week, you go there and withdraw $10,000 as your own gain. Now, based on that, you wrote the policy. And when it reached the time for you to go and get 10,000, then the insurance company tell you that no.
It's
no,
unworkable.
It's unworkable. This is not what they said. Meanwhile, you put the application based on what the agent told you. So that the estoppel in simple term will now mean that you, because the agent has said that to you, it must hold. So the insurance company cannot be able to withdraw what the agent said, which is assumed to mean that what the insurance company said, because what the agent said is what the insurance company said. So the estoppel will now compare the insurance company to follow that thing that agent said before.
Which is, yes.
Yeah, which is you have to withdraw 10,000 after 10 days. Yes. You understand? So that is what it is. So the Estoppel Act prevent the insurance company from going back to what they initially said. It is not the insurance company that will come and say it. Because the agents have said it, it's assumed that the insurance company have said it because the agent work for the insurance company. Is that clear to everybody? For those who are not here, please, that word, estoppel, is a very important word you have to put on your hand because you may see, definitely going to see it in the exam. The explanation is you understanding what it means, which means is a statement estoppel only compare the insurance company not to go back to to abide by what they said.
said.
What they said initially may not be to their favor. What they said initially may be to their favor. But the extoper prevent them from going back to what they said. They must abide by what they said. So that's why, as an agent, you have to you have to abide by what the principles of express authority, implied authority, and which other one? Who can remember which other one? We have three authorities that agents can work on: express, implied, and what? We said it.
Apparent.
Apparent. So
Express,
please,
implied, and apparent.
yeah, everybody should try and remember all those. We said it yesterday evening. We did all those yesterday evening. I'm just trying
Express
to.
is written.
Uh-huh.
Implied is unwritten. Then apparent is based action and words.
Good. So please, everybody, anybody, if you do not understand what she just said, write it down so that you can remember it. That is the three authority that every agent work on. You work on those three authority, please write it down. If you cannot remember, write it down. So when you look at it, you remember it, particularly when you're going for your exam. All right. Look at the extoper. It's a legal principle that protects consumer when they rely on incorrect information from an insurance agent. In simple terms, if an agent tells a client something about their coverage and the client acts on that information, the insurance company must honor what the agent said, even if it differs from the actual policy.
Actual policy language.
So please remember this. It's very, this word, it can throw you off in exam. You'll be looking at it, you'll be confused. What is this thing? What is this? Because if you look at it, you cannot look at it and get the bare meaning, what it means. It is to me, it's an odd word. So you just know what it means so that when you see it in the hall, you will not feel disconnected, please. All right, we are just recounting what we did yesterday. We get all this. We come to law of agency. The principles of law of agency. We talk everything about principles of law of agency. We talk about the agent authority. What you, the agent, what you, the producer, what you, the field officer, will work. As far as you are working with under an insurance company, the authority they give you to work can be in form of express, which must be written. The express authority must be written. It can be in form of implied, equally, it can be in form of apparent authority. So these are the three authorities that you work on. Anything you do outside this three authority, you are on your own. The insurance company must make sure you abide by these three principled authority. You can work on them. You do everything you are doing based on these three authorities. So remember that, please. The express is written, which means that express authority is written on the contract. It's a written. The word they use to distinguish them is express is a written authority. It's written in the contract. Now, the implied authority is unwritten authority. The implied authority is an unwritten authority, and which means it can be expressed, granted in writing. But however, it's very, very unwritten authority. It's something you should know. Now, the apparent authority is what? Authority that is based on action of your what? Boss, which means action of the company. And they have given you that apparent authority based on what comes around as you do your business. Based on the person's, probably your agent's action, there are some things you will not expect the insurance company to tell you to do. So those things are this authority we are being described. But the one that is you see and you know and you follow it by the law is what? Express authority. That is written in the contract. When you enter into contract with the insurance company to be the agent, that is what is written. Express authority. The implied is authority that is unwritten. It's not written, but however, is assumed that you should know it and you should do it. It's one of the principles of business, which you must do. Some things, the insurance company cannot follow you and be telling you what to do, how to enter this train, how to enter this bus to go to this patient room. And let's assume, for instance, you want to write a policy for somebody, and you told the person to come to your office. The person, no, he cannot come to his office. Can you come to my home? The insurance company did not tell you to go to the person's home to talk to him. Of course, the insurance company did not tell you where you will speak to the person. The insurance company said you should not speak to the person at the store. However, it's an implied authority, which you know. This agent, you have to reach that agent. Where are you reaching the agent is not specified. It can be at your office. It can be in the agent, customer's home. It can be in the customer's office. It can be in a store. It can be in a coffee shop. It can be anywhere. So that is what implied authority. That authority has given to you to speak to agent. However, wherever you speak to the agent, authority has been given to you. It's implied that you must speak to that agent. All right. So we always talk about the apparent authority. That is another type of authority. That one is based on what? Action, word, or deeds of the principal. Who is the principal we are talking about? Is the insurance company.
Insurance company.
Is the principal. Either you call it principal or you call it insurer or the insurance company. So when you come to agency law and agent, you now be hearing of principal. So when you hear principal, don't be confused. It's the insurance company. All right. So that's the three authority you have to work on. We talked about the broker versus the agent. Who is the broker? The broker is the person that works for himself
For the insured.
and he works for the insured. The agent take care of the insured and the insurance company. So you can see the agent is the middle person between the insured and the insurance company. The broker works for himself and works for the insured. However, since the broker grows from being an agent to a broker, at a point, the broker cannot do what?
Bind coverage.
Bind coverage. This is what you have to know. The broker cannot bind coverage, but the agent binds coverage through the insurance company. So, however, the broker can still go back to the agent or to insurance company representative to bind coverage. But the broker as a person cannot bind coverage. Please know all these differences. All right. Now that you are writing the exam, you pass the exam, you become an agent. For an agent, you climb to a broker. From being an agent, you can buy coverage through your insurance company you are representing. Now, you grow up to become a broker. Now, you are responsible for the insured. You cannot buy coverage now as what? A broker, but you can buy coverage through an agent or through a company's representative. And the agent you are buying coverage to, his own aspiration is to become a broker. You can see the circle. So which means you are working and holding other person on your hand to work with you. And that person you are holding on your hand, you want him to grow to your own level again. So it means that nobody is leaving anybody behind. That's how it is. So we talk of agent versus solicitor authority. Remember that solicitor does not have any license to speak anything about insurance. The solicitor cannot bind coverage. Solicitor cannot cannot write policy. So that is the difference. What do? Solicitor only there to help the agent in duties that does not relate to licensing. Issue that does not relate to licensing is what the solicitor does. Solicitor can go out and seek for clients, but can he speak about insurance? No, because he doesn't have a license to do that. So he works with the agent. Now, we talk about agent as a fiduciary. Of course, we have agreed here that agent represent the insured and the insurance company. So therefore, what it means that agents have responsibility on the insured and equally have responsibility on the insurance company. The broker has a responsibility on what? On the insured alone. And that's why the broker cannot bind coverage. So please let us know all these things so that it will not confuse us even in the exam. These are little things they will ask you in exam. So we talked about other legal concepts related to insurance. What again? All right. It's quite a previous section covered the fundamental principle of insurance contract and agency relation. There are several other important legal concepts that insurance professional must understand. These concepts affect how insurance claims are handled, how disputes are resolved, and how insurance professionals protect themselves from liability. So in this section, what we're going to do, we're going to talk about subrogation. We're going to about tort law. We're going to take professional liability coverage, E&O insurance for insurance agents. So subrogation are how insurance companies recover claim payment from responsible parties. The tort law and its impact on the insurance claim and liability. And of course, professional liability insurance, E&O insurance. If you remember, I talked about E&O yesterday.
Error and omission.
Error and omission insurance. So we're going to go deep into it. Subrogation. What does subrogation mean? It means that insurance companies go to the third party to collect what they have paid you, what they have spent on the claim you filed. Somebody must have caused the loss. The cost of the loss is this is where they will go to get the money back. For instance, in your car insurance, auto insurance, you hit somebody. All right, somebody hit you. You have comprehensive insurance. Somebody hit you. Now, your insurance company, definitely by law, by you having a comprehensive policy, we do what? We come make sure that your car is fixed. They're not gonna do you. They just fix your car, fix your car. They will now go and look for the person who caused the loss. That person who hit you, they will go to that person to get back their money they spent on hitting on your car. However, are they gonna get only that money they sent? No. They're still gonna get we add some charges. Of course, administrative charges. Of course, inconvenience charges will be added to what they're going to get to that person. So if they use $5,000 to work on your car, do you think they'll go back to get the $5,000? No. Of course, those who are doing that job came to work that day. Those people must be paid. So there must be administrative charges added to that $5,000. So they're going to bill it to the other insurance company or to that person, for that person to pay of what they have used to fix your car. So that's what we call subrogation.
Well, engineer, I want to ask you, is it only on when somebody has comprehensive insurance that
No. Liability insurance. For instance, remember, if you have liability insurance, if he's somebody, what will happen? You will fix that person's car. Isn't that true?
Yes.
Yeah, if you hit somebody with liability insurance, you fix that person's car. Your insurance company will fix that person's car. But they're not going to do what? Fix your own car.
Yes. You fix it by yourself.
You fix it by yourself. So in that way, the insurance company don't have anybody to go and collect the money. You cause the accident, they come and fix that person's car, then you go and fix your own.
Fix your own.
So that in liability insurance is very clear. If somebody hits you, the insurance company, you call the insurance company of that person who hit you. That insurance company will fix your car. Then that person who hit you will go and fix his own car, her own car. So it's much applied. Subrogation is much applied in life insurance. I mean, in comprehensive insurance.
Insurance.
Yes.
Auto insurance. Yeah.
Comprehensive auto insurance. So that's much where it's applied. It cannot be on the liability insurance. Yeah. All right. So that is subrogation. You can see subrogation in the exam too. TORT, T-O-R-T law, is a law that governs the insurance agreement itself. Insurance professional must also understand another crucial area of law, TORT law, the law that governs insurance agreement. So remember, when you fill the application and pay initial premium, if that's when you are submitting to the initial company, what did you do that time? You made an offer to the insurance company. You pay you fill the application, which is would say is a representation. After filling the application or statement, You send it with initial premium to the insurance company. What have you just done? You have made an offer to the insurance company. Then the insurance company will accept the offer by approving their application or denying it. If they deny it, what happened? They send back your initial premium. But if they approve the application, they have accepted the offer. Is there any contract at that point? No. There's no contract yet. You have made an offer, insurance company accept the offer by approving your application. Now, this application will be sent back to you through a counter offer, which the insurance company will do. They approve it, they send back that contract to you, which they regard as a counter offer. Let's assume that when the agent is filling the application, the risk level he used is a standard. And now when you submit the application, the insurance company, after due diligence and investigation, they found out that, oh, this person is not a standard, is now substandard. What will happen? They will now place you on substandard, and they have approved the application. They will now do what? Send that information to you through a booklet. They send that information to you through a booklet. Why are they sending information to you through the booklet? Because you have already fulfilled your own part of the contract consideration, which is what? Paying your premium and the application, which is what we regard as an offer. You made an offer. So when they send back the booklet to you, you have to go to the booklet. If you like what they have done, the counter offer they made, you will accept it by what? Signing up to form. One is what we call statement of good health. Two is what? A condition delivery receipt. You sign all those two things, you submit back to them, they got it back. Then what happened? Contract is now binding. Contract is now binding. So this is what you should know. So the tort law is what governs the insurance agreement. And who made that agreement? Is an agreement between the insurance company and you. So that tort agreement that tort law is a law that governs that agreement. Can somebody fail the tort law? Of course. You can decide not to take it. You can decide to take it. You can decide at that point they made a counter offer, they come back to you based on the change of your risk level, based on the premium change. You say, no, I can't afford this. You go your own way. The insurance company go their own way. After all, it's a contract of arbitration. Either you take it or leave it. They're not forcing you. It's you that made an offer to them. They didn't make an offer. So many insurance claims rise from torts, civil wrong, and understanding tort law is essential for proper evaluating and handling these claims. However, insurance professionals themselves can be subject to tort claims if they fail to meet their professional obligation. So, tort law guiding this agreement between you and insurance company. If at a point this thing is binding and you now begin to play hard game on the insured, or you now begin to play hard game on the insurance company, the tort law will come in. Tort law will keep you to make sure that you follow what you have done, what you have promised. For instance, if after continue paying your premium, you did not miss your premium for once, and the insurance company, you have the loss, and the insurance company refused to pay the benefit, what do you think will happen? The tort law will step in, and the tort law will not compel them to fulfill their own professional obligations. So that is what tort law does. So the tort law involves private wrongs that are independent of contract. By definition, tort is private wrong that occurs when one individual wrongs another by failing to act in reasonable or prudent manner. Tort law is different from criminal law because people commit crimes against society even if the victim is an individual. Criminal courts have jurisdiction over crimes, while civil courts preside over torts. So you can see it. Criminal courts cannot try a tort offenders. Is what? Civil courts. Although they may not likely ask that one, but it's good to know it. All right. simple negligence, gross negligence, willful and wrongful negligence. These ones are equally important. Simple negligence are agents forget to submit a client's application. That is simple negligence. That is an example of simple negligence. Gross negligence is that an agent consistently fails to maintain proper client's record. Willful or wanton negligence means that agent knowingly processes a fraudulent claim. That is willfully or wanton negligence. This is, you decide to do it. You know it's wrong and decide to do it. Now, gross negligence is when you continuously continue to do something that you know that is wrong. Then, simple negligence is just something you forget to do. You would have done it, but you forgot. So that was a simple negligence. Insurance agent errors and omission, professional liability insurance. Of course, one of the ways you can protect yourself, even as a professional working in the field, not even as a life insurance, not even as an insurance agent, in some of the professions, for instance, if you're a nurse or if you're a medical profession, medical field, definitely you are expected to have a liability E&O insurance. As a nurse working in a ward, on a unit, on a hospital, you may make some errors. So sometimes you don't know the importance of this until it occurs. Just like if you remember what I said yesterday, that if there's a way I can transfer all my risks to the insurance company so I can be freely minded, and honestly, it's good to do. But however, it involves some money. For you to bring everything around you, transfer it to the insurance company. Yes, you've paid premium. You have money, but some people do it because they have it. They can transfer all their risk to the insurance company. All their risk to the insurance company. And that is basically, that's what keeps the life going. If you can be able to transfer all your risk to the insurance company, you'll be in a right foot of mind. I tell you the truth. Because you not fear of anything. Although you will not willingly go and do something that will cause a loss, but at least you will have rest of mind. You have rest of mind. If you see people who have life insurance policy, you see that there's a way they think. There's this. No, honestly, there's this calmness. I don't know. There's this calmness in that person. In as much as you are paying the premium, but there is this calmness in you. If you have a life insurance, there is this calmness in you. Because the worst thing that can happen to anybody is that you are thinking about today, thinking about tomorrow. I think that's the worst thing that can happen to anybody. When you are thinking tomorrow and thinking today, thinking about what will happen in the next 20 years. Those people who have life insurance policy have calmness in their life. Calmness. I'm telling you. So, error and omission, in particular in this business we are into, you must have to have E&O. It's a federal requirement. It's a state requirement. It's an insurance company requirement. You cannot do business with any insurance company without E&O. Error and omission insurance. It's not expensive. It's just it's not a small thing. It's something when you pass the exam, you must have it. And you renew it annually. I think sometimes for something $, you renew it annually. So it's mandatory. Error and E&O is mandatory. For they can terminate your license if you don't have E&O. I'm telling you the truth. They don't joke with it. E&O, state don't joke with it, and insurance company don't joke with it. They can terminate your license if you don't pay your E&O. So it's very, very important. Very, very important for anybody. Legally, you don't know the importance until maybe somebody enters into a problem. That is when you know that this person has a problem, like this thing solves problem. I think we should go ahead. All right. What are the E&O exclusions? Some things you cannot see that you don't require E&O. Criminal act, illegal act, dishonest act, malicious act, libel and slander, intentional violation of any law, regulation, statute, or ordinance. Those are the exclusions from E&O. Those who does not require E&O. All right. I think we have gone through this chapter. But let's just have a rundown, a little bit rundown. As a chapter summary, we have explored the essential legal concepts that form the foundation of insurance practice. Of course, we did that. We begin with the 4 fundamental elements of valid insurance contract. What are the 4 elements? Competent parties, legal purpose, offer and acceptance, and what? Consideration. And we went ahead to describe the consideration. What are they? We said consideration is in 2 parts. I will use the word, what can the 2 parties on the contract bring to the table? Who are the 2 parties? One of the parties is the insurance company, and the other party is the applicant or the policy owner. What do they bring to the table for the contract to be binding? 1, what the insurance company brings to the table is what we call the promise to pay benefit, which in sometimes can be regarded as a insuring clause. Now, what did the insurance, the applicant bring to the table is what? The application or statement, which we called representation in the application. Whatever you write in the application is not a warranty, it's a representation. So what you bring to the table is what? Your application and the initial premium. So these are called the consideration clause. The consideration clause are what? 1, promise to pay the benefit. Who made the promise? The insurance company, which is what? Conditional until the loss occurs. 2, the application from the applicant is the consideration clause. And 3, the premium, initial premium that the applicant will pay. So these are the 3 facts on the consideration clause. Now, the 3 elements of a valid insurance contract, what are? Competent parties, legal purpose, offer and acceptance, and consideration. So this must be there before a contract can be said is a contract. Now, when we talk about void contract, in void contract, one of these elements are not there, which means if one of these elements are not there, is a void contract. That means that that contract does not even exist. In voidable contract means that 4 of this element is there. When 4 of this element is in that contract, what happened? One of the parties in that contract can decide to terminate the contract. That is voidable contract. So voidable contract exists, then one of the parties can decide to terminate it. But void contract is empty. It's not yet a contract yet because one of the elements of the contract is missing. So remember, we examine what makes insurance contract unique, including their status as what? Electric contract. Remember what we say, electric contract, in which one person benefits more than the other. Electric contract. I think everybody remember that. We learn how
unequal value now.
Yeah, unequal value, yeah. That one person benefit more than the other. Then we learn how insurance contract is a value contract. We differentiate it from indemnity contract. A value contract is life insurance contract. What it means that contract has a predetermined benefit. But the indemnity contract is contract you can do in a property. That contract is almost cash and carry because you pay, they will indemnify you or pay you or reimburse you exactly what you lost. So life insurance being a prime example of value contract that pays predetermined amount. Life insurance paid a predetermined amount, which means the amount you will pay has already been determined when the contract was initiated. Now we talk about the concept of insurability interest. You do not write a policy to somebody you do not have insurance interest on. So before you purchase insurance for anybody, you must have insurance interest on that person. And what is that insurance person? Anybody that can have a loss, anybody that if anything happens to that person, you'll be financially hurt. You financially experience a loss by that loss that person experienced. That's such a person, you have insurable interest on the person. So we went ahead to clarify important between warranties statement guaranteed to be true and representation, which is statement believed to be true. Remember, the difference between a warranty statement is a statement guaranteed to be true, and the representation, which is statement believed to be true. We talk about it. We talk about concealment, which is failure to disclose material fact. We also explore how agent authority works. We talk about express authority, implied authority, and apparent authority. All those are the authorities that the agent will work on. So on the agent, we talk about what the broker, the difference between the agent and the broker. We said a broker cannot bind a contract, but an agent can do what? Bind a contract. What does that mean? The agent can bind a contract through the insurance company. The broker can equally bind a contract through what? The agent or the company representative. So this is what we talk. Finally, we cover tort law and the importance of E&O. Of course, everybody now understands the concept that protect both insurance professionals and their clients. I think that's what we do. We remember this legal concept aren't just theoretical requirement. They are practical tools that help you serve clients effectively while you are staying with the legal and ethical boundaries. As you move forward in your insurance career, this principle will guide you daily decision and help you protect both your client and yourself. So that's exactly what we do. So let's watch this video and probably we answer the question and we'll close. All right.
Congratulations on completing legal concepts of insurance. You've just built a strong foundation in insurance contract law. Let's review the key concepts that will help you prepare to pass your licensing exam. We began with the 4 essential elements of a valid insurance contract known as CLOC: competent parties, legal purpose, offer acceptance, and consideration. These elements ensure that insurance contracts are legally binding and enforceable. Then we explored what makes insurance contracts unique. They're aleatory, unilateral, conditional, and contracts of adhesion. Aleatory contracts involve unequal exchanges. You might pay a little and receive a lot, or pay a lot and receive nothing. Contracts of adhesion are written by the insurer. The applicant must accept the terms as is. We also discussed the doctrine of reasonable expectations. Courts favor the insured when policy language is unclear. Insurance contracts are unilateral. Only the insurer makes a legally enforceable promise. They're also personal. Most policies can't be transferred except life insurance, which allows ownership assignment. Conditional contracts require the insured to meet specific conditions, like paying premiums and providing proof of loss. Next, we compared valued versus indemnity contracts. Valued contracts pay a predetermined amount, like life insurance. Indemnity contracts pay based on actual loss, like auto or health insurance. Then we explored insurable interest. You can only insure what you'd lose money on. For life insurance, insurable interest is only required at the time of application. We clarified the difference between warranties, representations, and concealment. Statements made on an insurance application are called representations. They need to be substantially true, but they're not part of the actual contract. Warranties are different. They must be exactly true and are part of the contract. If someone hides important information, that's called concealment, and it can void the policy if the facts are material. We also covered void versus voidable contracts. A void contract lacks a legal element and is never enforceable. A voidable contract is valid unless one party chooses to cancel it. Then we explored waiver and estoppel. Waiver is when an insurer voluntarily gives up a known right. Estoppel prevents the insurer from denying a claim if the client relied on incorrect information from an agent. We wrapped up with a deep dive into the law of agency and agent authority, 2 foundational concepts that shape how agents legally represent clients and interact with third parties. Understanding the scope of an agent's authority, whether actual, apparent, or implied, is key to navigating responsibilities and liabilities in real-world scenarios. Agents represent insurers and can bind coverage. Brokers represent clients and cannot bind coverage. Agents are fiduciaries. They must act in the best interest of both the insurer and the client. Finally, we covered tort law and E&O insurance. Tort law governs civil wrongs, like negligence. E&O insurance protects agents from liability due to professional mistakes. These legal concepts are essential for protecting your clients and yourself as an insurance professional. Next steps. Jump into the review notes. Challenge yourself by explaining these concepts to someone else and take the practice exam to solidify your understanding. You're making great progress. Keep pushing forward.
All right, so we are done with this chapter. Let's see what we're gonna do on. Let's see what we're gonna do on this. All right, so let's see. In the evening today, we're gonna do annuity. We'll do annuity in the evening. It's on chapter 9. The group insurance is on chapter 8. So we will know how we're gonna handle it. We are jumping the chapter. We're not jumping it because we want to jump. We are jumping the chapter to make sure that somebody who's going to take the exam away of annuity said he's not strong in annuity. So we have to go back this evening to finish up annuity with the person so that the person can go to hall and be confident enough. We're probably going to touch chapter 8 where we discuss a little bit about group life insurance. So we're going to do that in the evening. And when we finish it, tomorrow morning, we're going to go back to chapter 4 where we stopped, where we're going to stop today. So let's do these questions, about 12 questions. Let's do it and before we call it a day for this morning. So which of the following consists of an offer, acceptance, and consideration? Which of the following consists of an offer,
contract,
acceptance, and consideration? Any other person?
D.
Any other person?
Yeah, D as in David.
All right, somebody said D. Any other person? Is this
I
two
said
persons?
D,
All right.
Chinyere said D.
So D, let's continue. When must insurable interest be present in order for a life insurance policy to be valid? When must it be present for insurance policy to be valid? When is insurable interest be present? When?
It's
D
blurry.
as in David. D as
When
in
the
David.
application is made.
All right, so yeah. So remember, insurable interest exists when the application is made for it to be valid. However,
Yes.
we said insurable interest starts with the application and ends
And
with the
ends with
application.
the application.
Yeah. In health insurance, when we're talking about health insurance, insurable interest exists from the application to even when the claim is made. But in life insurance, insurable interest starts with the application and ends with the application. So we should know the difference between the two and when they ask them. So which of this is not a type of agent authority? Which
D.
of this is not?
Principal. D.
D. D as in David.
Yep. Then which of this is not considered to be an element of insurance contract?
Negotiating. C. C.
All right.
C.
Well,
D as in
I think it's like everybody is through with this chapter. So at what point does an informed agreement becomes a binding contract? At what point does an informal agreement becomes a binding contract? Remember, all right, anybody?
C.
Another person?
C as in Charlie.
Two persons say C?
C. C as in, yeah, cat.
All right. Mute yourself a little bit. Let me speak on this. Yeah, mute yourself a little bit. The person that's all right, thank you. So the question is that at what point does an informal agreement becomes a binding contract? And everybody say when one
So
party
what do you mean by
makes an
informal?
offer
Informal.
and the other party accept that offer. Let me ask this question from our discussion this morning. If the applicant makes an offer, and what is that offer? The application and what? The initial premium. That is the offer. Is the contract binding? Huh?
No.
Why?
Because it's just an offer.
Good.
Yeah.
All right.
And
So,
the insurance agents, they will make their own counter offer.
all right.
Or
So
the insurance.
the insurance company have to make their own counter offer. Remember, when the agent, I mean, when the applicant made that offer by submitting the application and the initial premium to the insurance company, it's an offer to the insurance company. The insurance company will accept the offer by approving the contract, approving the policy. When approve the policy, is it a binding contract yet? No.
Yes.
No. They approve the contract, approve the offer. It's not a binding yet. It's binding when the insurance company, in as much as you have paid the initial premium, that contract is not binding. It's binding when the insurance company now goes through your application, definitely going to make a counter offer by agreeing to what you have said. That is a counter offer. They send you back a paper, which you sign and return back to them. Now the contract is binding. I think I said it several times. So the mere giving you paying the premium and submitting the application, that contract is not binding yet. So if they deny you at that point, what do? They're gonna send you back your
The
initial
premium.
premium. So that will tell you that contract is not yet binding. A binding contract, none of the party has the right to go into it without in consultation with the other party. So when the insurance company made that counter offer to you, you now submit delivery receipt and the statement of good health back to them. They will now take the offer. The offer now becomes binding. At that point, you can no longer make a changes in your contract. The insurance company does not have the right to make changes. If they want to make a changes, they have to get your consent. And you too do not have a right to make changes on it. So that's when we say the contract is binding.
Engineer, but hold on, don't continue. I want to understand why I tried that bit.
All right.
I want to understand why, what do you mean by informal agreement?
All right. Informal agreement. At what point does an informal agreement becomes a binding contract?
Binding contract.
Remember, when the offer is met and acceptance is done, it becomes an agreement. Is it clear to you?
Yes.
When you submit your application with initial premium, the insurance company accept your offer by approving it. And when they accept the offer by approving it, what it becomes is now an agreement. It's an informal agreement. It's not yet a contract. It's not yet a binding contract. Is that clear?
Okay.
Because of the word informal, maybe that's
informal. That word got me confused.
What you base your answering the question is agreement. When you make the offer, insurance company accepts the offer. Is an agreement. It's not yet a contract.
Okay.
Yeah. So that's what we guide you. All right. So this one says insurance policy are offered on a take it or leave it basis.
Adhesion. B.
All right. So I think this chapter is easy. This chapter is very easy. Taking receipt of premiums and holding them for the insurance company is an example of what?
Commingling.
Commingling. It's commingling. Remember, I said.
Yes.
Oh, no. Taking receipt of a premium and holding them for the insurance company is an example of fiduciary responsibility. No. If you take a premium, you have to submit it commingling. If you hold it, it's a commingling. Fiduciary responsibility is what you should do what you have to do to the insurance company, or what you should do to the insured. That is your fiduciary responsibility.
Wait. Commingling is when you add your personal money to the company's money. It's commingling.
It's not only when you take your money, when you take your money and give it to the insurance company. I mean, mix it with your money. When you take premium and mix it with your money, is commingling. If they write a check to you, you hold that check and keep it with you, is a commingling.
So what did they say is fiduciary responsibility?
fiduciary responsibility is, to me, I can't understand this question in
I
particular.
don't know why they
To
said
me,
so. It's supposed
the
to be
fiduciary responsibility is the responsibility you have,
when you
your
take your
agent,
as
an agent, you are
client
insured.
concerns in their first.
Excuse me.
Can you allow him to explain to for everybody, please?
So what I'm saying is this, the fiduciary responsibility is what you, as an agent, hold to the insured and what you hold to the insurance company. Remember, you are the medical
problem.
Then
I think the answer came from these other three answers are just stealing. And the other one is separate.
Yeah, you may be right. All right. I think I see why the answer is. All right. I see something here. Is a receipt of premium. It's not even the premium. Look at this word here. Receipt. Is a receipt of a premium. So when you take a premium and you hold a premium, it's commingling. Remember, premium is money. I hope everybody knows that premium is money.
Mm-hmm.
Yeah, when you take it from insured and hold it or mix it with your own money, premium can be in form of cash. It can be in form of check. So if you hold those premium, you don't submit it, or you mix it with your own money, or you put it in your pocket, it's commingling. So I know why they use fiduciary responsibility. The receipt
It's because of the receipt.
The receipt of premium and holding them for the insurance company is an example of, is their responsibility, of course. So you are working for the insurance company. So they are correct. Yeah, it's a receipt. I do not see that word receipt. It's a receipt. It's not the premium. The receipt of a premium is you get, everybody know what receipt is. You do not receive premium. If you receive premium and hold it, now it's commingling. But this is a receipt you got from a premium. So is what coming is not commingling. So let's just take it that way. But however, I want everyone to know fiduciary responsibility, the responsibility you have to your insurance company and to the insured as an agent, which means their duties to the insurance company are your duties to the insured. That is their fiduciary responsibility. So that is what we should know. Commingling, if you see commingling in the exam, is when you receive money, initial premium, or any money from the insured, and you mix it with your own money. And when you receive a check from an agent, from insured, instead of submitting to the insurance company, you keep that check with you. That is commingling. So I want everybody to know that. And again, there's some question that will come in this one, in this type of receipt something. One of the questions that will come again is when the applicant wrote a check and make mistake on that check, what will happen? And they submit to the insurance company returns the check back. They will ask you, what are you gonna do? You have to bring back the applicant for him to come and write new receipt in which he or she will address the company's name on the check. And if there is duty for him he made a mistake on that check, he can equally pitch an initial on it. So those are it. Yeah, hello. Yeah. So those are the constitution clause of an insurance contract includes what? What are the constitution clause of an insurance contract?
A.
B. All right. So any other person? Is it A? Somebody say A. Somebody say B.
I said A.
D. Oh, D. All right.
I said A.
You see, so the schedule and amount of premium payment. Consideration clause of an insurance contract includes what? The schedule and amount of premium. summary of the coverage provided. How can somebody even say consideration clause of the national contract is a summary of a coverage provided? We can't even say this.
That's a contract.
Of all these things we say today, because nobody here who knows everybody here supposed to know what consideration clause is. I shouted it today. I've said it several times. One, let me repeat
several times.
Consideration clause is in three. One is promise to pay benefit, which is consideration clause for the insurance company. Sometimes you can call it insuring clause. Then consideration clause in part of the applicant or the insured is what? The application and the initial premium. So there are three consideration clause. One, promise to pay benefit by the insurance company, the application by the applicant, and the initial premium by the applicant. So that's the three consideration clause. So there's no way summary of coverage is there, please. All right. When third-party ownership is involved, applicants who happen to be the stated primary beneficiary are required to have what? This one I have to think a little bit. When a third-party ownership is involved, applicant who also happen to be the stated primary beneficiary are required to have what? Can I help you? Can I help you? Can I help
C.
you? Can I help you? Yeah, please. This is a private number. Can you remove him from your call? Is this not Monica? I don't know who's Monica. Please remove him from your call. Is that okay? Right. Right. So who said what's the answer?
C.
All right.
A.
Somebody see.
I said A.
So anybody supporting, anybody should break the tie.
Okay, C. Insurable interest.
All right. So insurable interest in the proposed insured, of course.
Oh, yeah, I got it.
All right. So which of this is considered a statement that's assured to be true in every respect?
Presentation. C.
Which of this is considered a statement that's assured to be true in every respect?
Warranty.
No.
So anybody supporting her? A?
No.
Guarantee. A.
Oh, A.
All right. It's warranty. Your warranty is a statement assured to be true in every respect. All right, that is it. So I'll see everybody in the evening. Remember what we say in the evening? We're gonna deal with chapter 8 and chapter 9, which is chapter 9 is annuity, and we will talk a little bit on chapter 8, which is life insurance. Then we talk about annuity. So it's not that we are not jumping all the other chapters. We are going back to them, to the chapters, but we want to help somebody who's writing the exam.
Yeah, those two chapters, that chapter 8 and 9 is very important for me before I go.
Right, so
my exam is around the corner.
So we're gonna do it. Then when we finish it, we go back to chapter 4. So from chapter 4, we still go back to 5, 6, 7, 8, 9. So we're gonna stay past chapter 9. We're gonna stay past chapter 8, but we have to go back to we have to do it today. So we now go back to chapter 4, start from where we stopped. All right, so see everybody in the evening. Good day, everybody. Bye.
Thank you.
So, Engineer Bad, don't go yet.
Uh-huh.
The dental insurance, were you able to find it with the group? We are doing the group insurance, group health insurance tonight. How about the dental insurance?
You said?
How about the dental insurance?
Yeah, we're gonna see it is on chapter 8.
Okay.
Yeah.
It's like health
So that is
insurance.
the group thing. Yeah. Annuities and group health and dental.
Yeah,
That is right. That's it.
Yeah, we're gonna see them there.
Okay.
All right. Good day, everybody.